to censor what the public says. And I will ask each and every one of you, if you appear at a public meeting and you say something, whose summary do you think is more accurate? One you provide or one they put in? And what I want to do is ensure that members of the public who have comments get those comments in the minutes as they intend. And Ms. Blackman with her, oh, they might say something and then write something different or whatever, is really wrong in the sense that if I summarize my things and happen to use different words to summarize it, it is still what I meant to be in the public record. And that's what this is about. This is about getting into the public record things that you want the public to know about, and do it in a way that the members of the public who review these minutes are able to see that someone spoke up and said something is wrong. First Amendment says right to petition government for redress of grievances, and if you disagree with the government, you have the right to say it, and that is free speech, and that free speech right extends to having it accurately represented in the official record. And that's what they're trying to do. They're trying to do everything they can to keep critical comments out of the official record and put somewhere else where hopefully people won't see it.
Thank you. Ms. Blackman, so can you respond, can you leave that right there for a second, Mr. Harris? So why would you, just clarifying, if he was there and gave you his piece of paper with his statement, so that's what he said, that's in the Bible. Why do you then have to do, in addition, addendum for a summary of this comment when it's right there?
I did for his comments?
Yes, you have to see addendum for a summary of this comment submitted by the speaker, but his comments are right above there. Correct, right?
They're the ones he did.
It's parenthetical at the end of that paragraph.
Okay, if it is, then that was probably a mistake. Because what I can do,
It was probably a mistake.
Because I have been including his verbatim. So
there is no,
there is no addendum for his, so that is a mistake that needs to be corrected on the minutes.
Okay.
But for the other people to do it later, it is. And I just want to say again that my understanding is the official record of the meeting is the audio tape or the DVD. And if there was something to go to a court or something, that would be a transcript of that. It would not be necessarily what the minutes, what I have put down as a summary of anybody's statements. They would go back to the tape or to the video,
but
the official transcript.
Mrs. Blackman, you do understand that it is about the public's access to those minutes and the correct, accurate access to the minutes, and the public is easily accessible to the minutes, but not maybe so easily accessible to the tape recordings or other items of that maybe that you technologically advance them to get access to, but it's, you know, for the past 100 years, the minutes, the written minutes have been the record that the public has access to. So it's important to have those correct, regardless of it is later used in a court of law or other judicial or quasi-judicial use.
I agree, and the addendum is a part of the minutes. The attorneys have told us that an addendum is a part of the minutes, just like any other part of the minutes, and it's referred to by reference, and it's part of it. It's in the packet that goes out. It's not a separate document.
Obscuring. Let's not forget science, law, and medicine are very exact sciences. They have rules, they have procedures.
Okay, I do, but I also, it has been sent to the Ethics Commission in the past.
It has been sent to the Ethics Commission.
The Ethics Commission has not decided to hear it.
Naturally.
They have said the matter was not calendared.
But Ms. Blackman, not to interrupt you, this matter is once again before the Sunshine Ordinance Task Force, and we have previously decided in a certain manner, and regardless of what the Ethics Commission, their decision doesn't overrule our rulings on how manners of sunshine and the actual ordinance should be applied.
I understand. But you are talking about sending a recommendation to the Ethics Commission, and it's one that's already been sent. And we could be here every
when he says that they don't overrule, when they
this,
don't take the cases, they've overruled.
Every month's minutes, because
when there is no
our commission has decided
enforcement,
this is how
it's
we're
overruling.
going to do the minutes. They're following the direction of the city attorney.
It's a wonderful hair-splitting thing, but it's not accurate.
The staff's letter has agreed with that.
CYA, I got my thing from the city attorney, that's all that matters. Thank you. Next victim.
Okay, I guess part of where I am with this, the ordinance allows a member of the public to submit a brief written summary, which shall be included if not more than 150 words.
Shall be.
The ordinance does not, in my view, give the public or anyone else editorial discretion over the minutes.
In his view.
Choice about how to characterize or summarize comments in the minutes generally is left to the body, so long as the minutes accurately reflect the actions taken pursuant to the order, pursuant to the charter, which requires that a record be made of actions taken by city bodies.
That, of course, is his opinion.
That's my view. Is there
Yes, his.
some other belief that somehow the editorial work on minutes is left to anyone?
Once
other
again, she
than
claimed the plain
commission?
English language
If
definition.
not, then I believe that the summary should be included in the minutes and, as was explained, can be both summarized as to public testimony and included verbatim as part of the minutes as the standalone statement. And so long as that
But not in the body
occurs,
as an amendment.
I'm not of the view that there's a violation, and I'm not inclined
Muddy
to
in the waters.
support a referral. I would
Muddy in
like
the
to
waters.
ask at least of our committee, pursuant to the paragraph towards the end of page 9 of the packet, the library commission was asked to make changes within 5 business days and appear before the committee. What happened at that meeting or at subsequent meetings, and what exactly has occurred since the order of determination issue?
For something he wanted reheard.
Member Washburn, who chairs the Compliance Amendments Committee, is welcome to correct anything I said. My recollection is that this did come before the Compliance and Amendments Committee. The exact date I don't recall, but it did come before us. At that time, hearing from both the complainant and the respondent, the feeling we believe that the respondent was not present. Okay.
Naturally, the respondent was not present.
May 15. May 15. Ray Hart provided an update of the complaint and responded to questions raised throughout the discussion. There were no speakers in support of the complainant. The respondent was not present to provide an update and respond to questions. There were no speakers in support of the respondent. A question and answer period followed. The complainant provided a rebuttal. Member Nee, seconded by Member Wolf, moved to refer the matter to the task force with the recommendation that it be forwarded to the Ethics Commission. There have been no further proceedings on this matter until now.
Because the Ethics Commission would not take it up. Rigged is as rigged does.
Can we get any rebuttals? Can I get a rebuttal from the complainant or respondent? I can't see. No? Okay.
The respondent has indicated she wishes to make no further remarks.
Great, okay. Complainant, Mr. Hart? So you get 3 minutes.
Thank you, and Ms. Osberg, if you let me know when I have my minute left, please. Again, let's not reinvent the wheel. Bottom line is 10054 said in the minutes means in the minutes, and that's a clear reading. That's what the ordinance says, regardless of how the city attorney wants to reinterpret it. 11054 said it was also in the minutes means in the minutes. 11071 against the city attorney found him in violation for advising people that in the minutes was satisfied by putting it as an addendum.
What?
11088 was a violation found against the Ethics Commission for not putting them in. And it is not any big surprise that they sent me a 134-page justification as to why they weren't going to do it. And yet at the last meeting, they approved 2 sets of minutes with my 150-word summaries in the body, just as we're discussing now. And very frankly, I think it is really ludicrous to put the members of the public in a position where we're substituting, contrary to what Mr. Pilpel says, the version that the government wants in for the version that the citizen says they have said and want presented. Bottom line is, I have the right to say anything I want, and I also feel that because it's free speech and petitioning government for redress of grievances, I have the right to have that appear as I say it should appear in the minutes where it is, not their version of what I said. I think any citizen has the right to do that. It's an extension of our First Amendment rights. And to say that the body has the right to rewrite our statements and editorialize them is to say they have the right to censor them, which is what the Brown Act is and the Sunshine Ordinance are supposed to protect, to ensure that the government cannot censor critical comments. And that is why they're fighting. And the bottom line is they keep making this ridiculous argument that whether it's in the body of the minutes or addended to the minutes, it's the same thing. Well, if they really think it's the same thing, what difference does it make to them? It makes a difference to me. I want my comments where they were made. And the official record, as far as I know, of any public meeting in this city are the minutes. And they are supposed to be an accurate representation, and the ordinance provides each and every citizen the right that if you don't feel your comments are being accurately represented, to put in a 150-word summary, whether it's at the meeting or later, to say this is what I want in the public record as my comment.
Thank you. Member Yee.
I'd like to move that this matter be referred to the Ethics Commission for willful violation, and if there is a second, I would like to discuss the matter.
I second the motion.
Madam Chair? Okay.